There's a case challenging the National Firearms Act and its restrictions on short-barreled rifles that's now before the Supreme Court. But once again, the Trump Department of Justice is defending the NFA and arguing that the Supreme Court could refuse to hear this case. Let's talk about what's happening in this critical challenge. Before we get started, if you want to support the channel, one of the best ways to do that is to subscribe. In this video, we're covering another important NFA short-barreled rifle challenge currently before the Supreme Court. This case is called United States versus Robinson, and it challenges the NFA and its restrictions on SBRs. In this petition, the plaintiff is asking the Supreme Court to rule that the NFA's restrictions are unconstitutional under the Second Amendment as they apply to short-barreled rifles. This case was previously decided by the 11th Circuit Court of Appeals, and in that ruling, they determined that the NFA does not violate the Second Amendment. They concluded that the NFA's SBR restrictions are constitutional, even considering what the Supreme Court recently said in cases like Bruin. This has now led Mr. Robinson to seek Supreme Court review. The Trump DOJ recently filed their response to this challenge. And once again, they're arguing that the NFA is constitutional under the Second Amendment, that it does not violate the Second Amendment, and that the Supreme Court should refuse to hear the case. This isn't surprising because recently we saw the Trump DOJ do the exact same thing in another SBR case that was before the Supreme Court. That case was called Rush. In those arguments, the Trump DOJ made essentially the same points. They argued for the Supreme Court to deny review of that case. They said the NFA does not violate the Second Amendment. And in that specific case, they also argued that the Supreme Court should deny review and potentially address similar firearms ban questions in a different case, maybe one dealing with state rifle bans. But this is now the second time in just a month that the Trump DOJ has defended the NFA and argued against Second Amendment protections. The facts surrounding this case are interesting. Back in 2022, law enforcement responded to a complaint about a suspicious vehicle parked outside a home in Florida. When the officers arrived, they observed that Mr. Robinson was asleep in the vehicle. He was asleep in the driver's seat, and they also saw the buttstock of a rifle next to him, so they spotted a rifle in the car. Officers flashed their light into the window. They woke up Mr. Robinson and asked him to exit the vehicle, but Mr. Robinson responded by trying to drive away. Eventually, he was stopped. They got him out of the vehicle, arrested him, and then searched it. When they were searching the vehicle, they found a short-barreled rifle and also a separate upper receiver. Mr. Robinson explained that he had bought the rifle in Tampa, Florida, and that he didn't know he needed to register it. A search of the National Firearms Registration and Transfer Record revealed that the rifle was not registered to Mr. Robinson. This went to court, and after a bench trial, the district court found Mr. Robinson guilty of violating the NFA by possessing an unregistered SBR. In response to that conviction, they sentenced him to 18 months of probation and 6 months under house arrest. Mr. Robinson then appealed that conviction to the 11th Circuit Court of Appeals. On appeal, he argued that this statute and his conviction based on the NFA violates the Second Amendment and what the Supreme Court recently said in New York State Rifle and Pistol Association versus Bruin. He also argued that the NFA is an unconstitutional tax on the exercise of constitutional rights and that it exceeds Congress's powers under the 10th Amendment. However, on review, as I mentioned, the 11th Circuit rejected all of Mr. Robinson's Second Amendment claims and also rejected those tax arguments. When it came to the Second Amendment arguments and the whole question about the Second Amendment, they relied heavily on the Supreme Court's Miller ruling. They stated that Miller already determined that short-barreled shotguns are dangerous and unusual weapons and therefore can be restricted. The court believed there was no significant distinction between short-barreled shotguns and short-barreled rifles, and therefore Miller still stands as valid precedent, and also applies to SBRs. They stated that until the Supreme Court changes their rulings and clarifies this whole SBR issue, they are bound to follow Miller. In rejecting the tax arguments, they did something a little different. They claimed that Bruin's ruling forecloses that type of argument, since Bruin contemplated that some objective restrictions like fees, tests, background checks, and other things like that could be permissible under the Second Amendment. Therefore, they struck down the tax argument, saying this is a permissible restriction. It operates objectively. These registration requirements, background checks, and all of this are shall-issue permit-style systems that are potentially lawful under Bruin. Now that ruling is up for review in the Supreme Court. In this petition, Mr. Robinson presents two questions. First, he asks whether federal criminal punishment for the possession of an unregistered short-barreled rifle violates the Second Amendment. Second, whether federal criminal punishment for the possession of an unregistered short-barreled rifle exceeds Congress's taxing powers under Article 1, Section 8, Clause 1 of the Constitution and the 10th Amendment. Originally, in this case, the government waived their right to respond to the petition, but they were then ordered to file a response by the Supreme Court, and we just got the response from the Trump DOJ. In the response, the Trump DOJ continues to argue that the NFA and its restrictions on SBRs do not violate the Second Amendment. Because of that, they're asking the Supreme Court to deny review of this case. In this brief, the Trump administration argues that there is no meaningful distinction or difference between short-barreled shotguns that were addressed in the Miller case and short-barreled rifles, which are at issue in this challenge. Therefore, they argue Miller stands as valid precedent, which is controlling in this case. They also state that Robinson's arguments that these weapons are now in common use for lawful purposes lack evidence. They argue that short-barreled rifles remain not typically possessed for lawful purposes and that they are dangerous and unusual weapons primarily used by criminals. In this argument, they state that like its historical precursors, the provisions at issue here regulate the size of firearms but do not prohibit any class of firearms altogether. And significantly, because SBRs combine high destructive power with easy concealability, they are especially susceptible to criminal misuse. So the Trump administration, like the anti-gun groups we've seen before, tries to frame SBRs as these highly dangerous weapons that are primarily used by criminals and are used vastly in criminal activity. They're not used for lawful purposes but are an item picked primarily by criminals. Now, we all know that in fact is not correct, but those are the arguments being made here in this brief by the Trump DOJ. They then go on once again to try to hide behind the argument that since there is no circuit split on this issue of the NFA's constitutionality under the Second Amendment, the Supreme Court should deny review of this case at this moment. They argue that every circuit court to consider this type of issue, both before and after Bruin, has upheld the NFA's short-barreled rifle and short-barreled shotgun provisions, and until there is a conflict in the lower courts, they essentially argue the Supreme Court should pass on this case and not address this issue. Now, one interesting thing in this challenge is you don't see them mention, well, deny review of this firearms ban case but take up another rifle ban case. You don't see that in this challenge. They did mention that in the Rush case. You don't see them argue that here. Instead, they simply say the Supreme Court should deny review of this challenge. So this is now the second NFA SBR Second Amendment challenge that has been sent to the Supreme Court. And this is also the second time in just the last month that the Trump administration has defended the NFA and claimed it does not violate the Second Amendment. So once again, the Trump administration has argued for the Supreme Court to deny review of an NFA and SBR challenge. That's currently what's happening in another critical NFA SBR challenge seeking Supreme Court review. The Trump DOJ is fighting against it. And now this is going to head to conference, and we're going to see how this plays out. As we get more information as it develops, I'll let you guys know. If you like this video and want to support the channel, one of the best ways to do that is to subscribe. But as always, thank you for watching. Don't forget to like, comment, and subscribe.